Any real estate agent shall not facilitate the sale of any unit in a project that has been registered under this law, until that agent registers with the RERA body. This is again a negatively phased law. It begins with a no. The agent has to formally apply to RERA body, submit the application and documents and pay the fees to register himself as an agent. Section 9.3 is over empowering the RERA body. It uses the words within such period, in such manner and upon satisfying itself of the fulfillment of such conditions, as may be prescribed. This means that RERA body can add any amount of bureaucratic red tape here and exploit the agents before registering them. Finally, the RERA body will register the agent to operate in only one state, Oregon Union Territory. The agent will have to reapply to register in another state and pay the fees again. If the RERA body wants to reject the registration of an agent in writing, the RERA body has to record reasons in writing and hear the agent and his lawyer once before rejecting the application. Section 4 says that RERA body fails to communicate about the registration of an agent within the specified time period, it's deemed that agent has been registered. This is a favorable section to the agent and ensures that RERA body takes a decision and does not keep his application hanging. Every agent will get a registration number, and this should be quoted in every sale brokered by that agent. Note: Section 6 says that registration is only for a period and the agent has to renew his registration and pay the fees again. So for lifetime the agent has to apply multiple times for renewal of his registration and pay the fees again. RERA body may revoke the registration of an agent, temporarily or permanently. If the agent's application is found to be fraudulent or if the application has misrepresented facts, or if the agent has violated or breached any conditions of his registration or violated the RERA laws and rules. Finally, the proviso to Section 9.7 says that before revoking the registration of an agent, the authority shall hear the agent or his lawyer once. Section 65. If real estate agent defaults or violates any orders or directions of RERA authority, the penalty is calculated on a daily basis and the maximum is 5% of plot, apartment, or building brokered by him. Section 66. If real estate agent defaults or violates any orders or directions of appellate tribunal, the penalty is calculated on a daily basis and the maximum is 10% of plot, apartment, or building brokered by him, and he can be jailed for a maximum period of 1 year. Every registered real estate agent shall not broker the sale of units in a project that has not been registered under this Act or if the registration is revoked or suspended by the RERA body. Every registered agent shall maintain and preserve books of account, records, and documents as prescribed. My view is that this Act is treating the agent as an servant of RERA. The agent should not do any unfair trade practice. That is, he should lie or bluff to sell any apartment, plot, or office. Agent should tell a lie about the services and false claim that they are of any particular grade. Agent should not lie about the promoter having any approval which the promoter does not have. Agent should not lie about any services or his credentials. Agent should not advertise or allow advertisement of any services that will never be offered. Agent should ensure that consumer has all the information and documentation about the project. Agent should do other functions that are prescribed in future. But to prove fraud of any agent or promoter, the ality or consumer has to be smart enough to record all their conversations in a mobile and preserve it for future reference.